Going live. Okay, well, welcome to the a hearing of the Land Use and Ethics Subcommittee. We are just meeting today to talk about a couple ethics bills that were presented to the committee last week. We are going to start with HB 1058, Delegate Stewart's bill, and then have a discussion about HB 1229 as well. So we are very fortunate today to have several members of the State Ethics Commission joining us, as well as Dia Daly, our trusty ethics counsel who never steers us wrong, and Patrick, our awesome committee counsel here as well. So let's start with HB 1058. This is a bill that was presented last week by Delegate Stewart. Patrick, do you want to remind folks what this bill does, and then let's open it up for questions.
Okay, this bill does a lot of things.
It does.
It requires ethics training for state officials, that's mainly all the way from the governor down to sheriffs and the like. Requires disclosure of the participation in a matter despite disqualification for conflict of interest to the presiding officers in the Ethics Commission. It requires, if the governor, lieutenant governor, attorney general, state treasurer, controller, or an agency head takes executive action that will have material financial impact on the person, to provide notice to the Ethics Commission and the Joint Ethics Committee. If the Ethics Commission allows an employment or a financial interest by the governor, lieutenant governor, attorney general, state treasurer, controller, any advice must be provided to the Joint Ethics Commission, Joint Ethics Committee, excuse me. The bill expands the prohibition on the use of confidential information obtained through state employment to former state employees or officials. Requires disclosure of contractual relationship with quasi-governmental entity, including by any businesses that the person may own or have certain ownership in. Requires disclosure, when you're required to disclose businesses, you're supposed to include under the bill trade names and other names that are used for the business. Requires disclosure by the governor, lieutenant governor, attorney general, state treasurer, controller of ownership of 10% or greater of a for-profit business and the name of each person each other person that owns 10% of the business. And finally, it includes certain subsidiaries as business interests to be reported in financial disclosure. Delegate Stewart, is that pretty much it?
That sounds good to me. A+.
Great. Thank you. So we had a good committee discussion about this, a lot of back and forth, just questions. But do members of the committee have questions, especially now while we have Dia and the State Ethics Commission here? Any thoughts or questions about how this bill would work in action? Delegate Holmes?
Yes, I'd like to get Dia and others' opinion on if there's anything else we should be looking at in this bill, so I can get their input into this legislation, if you don't mind.
Sure, of course. Dia, you want to walk us through anything you think we should just pay attention to, not because you're concerned about it, changes?
So I did have a little bit of a thought on the training piece, the expanded training. One thing you may want to consider is, what do you want to do for incumbents? Do you want all those people, all 24 sheriffs, all registers of wills, all 24 clerks, do you want them to come in and get training now? Or if you look at what we did when you required certain state employees to get training, you basically said, anyone who took the position from this day going forward had to get training within months of taking the job. So something you might want to think about just for clarity. There was also an issue that raised. They don't like being included in the definition of a quasi-governmental entity. I believe there were some concerns in recent years about not knowing when people had certain relationships with So you could get at that without calling them a quasi-governmental entity. When you add those additional disclosures, you could say, an official who has this relationship with a quasi-governmental entity or needs to disclose the relationships. It doesn't regulate the relationship at all. It just says, hey, we need to know if you have this relationship. Those would be the two things I'd highlight for you. I'm sure the Ethics Commission has some things they'd like to share as well.
Sure. Kate or Jennifer?
Hi, this is Jennifer Alger, staff with the State Ethics Commission. I think Dia's point about whether or not the training is going to be something that's retroactively applied to all of the state officials, it would be helpful for us to know your thoughts on that, just to clarify that. I think what our office was thinking with that is we will be doing a separate electronic training module that will be geared toward those executive branch state officials to capture all of that, because there will be some things that are different for the elected officials than regular state employees that would take our normal training. So I think that's the way we would accomplish that. So any clarity on who's really required to take that training would be helpful there. And I agree with Dia's other point.
Can I ask one question about that? So, I mean, if you're creating the training module anyway, and people need to be trained anyway, it's not a question of an added cost for more people. It's just a question of clarifying that everybody needs to do it. Is that correct?
Oh, no, we have to create a totally different module for the elected officials, because some of their requirements in the ethics law are different. And some of their reporting requirements could be different. Gift exceptions are different. So there is that added cost that was in our fiscal note.
Right. Sorry, I was not clear in my question. I just meant regarding your question about whether the training would apply to people, incumbents.
Oh,
or
yes, you're right.
Okay. Right. Okay.
That doesn't matter. It's just clarity of getting the word out to everyone that we would need to get the word out about the training requirement.
Okay.
Thank you.
Great.
I would just remind the committee that when the ethics training was put into the law, the existing state employees were exempted at the time.
Okay.
Which included me.
I feel like even if you're in office, perhaps the people who've been around, I mean, we all need it, I guess, if we decide that a training is worth having, it's worth having for everybody, I would think, not just new people. And we did a new training a couple of years ago, right after we started, when we passed the bill. So we all were retrained in a much more in-depth ethics training than when we first started, and it was helpful. Other questions or thoughts? Yes, David Stewart.
Thank you. I was going to actually just bring up the point that Dia's already mentioned regarding the quasi-governmental issues, since that was kind of the only opposition that we heard from. And I guess just to clarify, Dia, what you're saying is that because UMS's opposition really stems from the fact that they don't like to be called a quasi-governmental entity, I understand that probably has like other repercussions for them, like around public information requests or whatever. So they just don't want that precedent to be established. And so what you're saying is that a potential amendment could be, well, it applies to quasi-governmental agencies, and then it also applies to some of these other named agencies that we're talking about here, like, for example, UMS, and then list UMS in that category. Is that what you're saying?
That's exactly
Okay.
what I'm saying.
Cool. Yeah, I just wanted that makes sense to me. I just wanted to clarify
That makes sense to me too. Delegate Clark, that makes
sense. Question, is UMS a quasi-government agency?
Well, that depends on who you ask, it turns out.
Well, maybe the Ethics Commission should be the one to make that decision as to whether they are or not. And if they are, then they should have to, go with everybody else. I mean, I don't know that we should just single them out because they don't like being called that, or remove them from anything that has to do with any ethics stuff.
The state ethics, I'm sorry, Delegate. The State Ethics Commission, this is Jennifer from the Ethics Commission staff. I think maybe at the time they were formed, the State Ethics Commission had previously determined that they were not an executive unit of state government whose employees and members are subject to the public ethics law. So that would be pretty much the extent of the State Ethics Commission's determination on where they fit. Otherwise, I think it might be a question that's more geared to the Attorney General's office than the State Ethics Commission.
Well, then the question should be, has in past experience, right now, do they practice under State Ethics Commission rules?
No.
No. I guess the question is, should they be? And is there things that have happened in the not so long future going back to give us reason to believe that they should be under the ethics, the guidance of the Ethics Commission, State Ethics Commission? I mean, we could say, maybe we need an Attorney General's opinion on that, or maybe as a committee, we should make that decision.
Yeah, well, I think there's also the question of, in this bill, the concern was just that we sort of singled them out because it says quasi-governmental entity means an entity that is created by state statute, et cetera, et cetera. And then it says, and includes the University of Maryland medical system. And I think what Dia was suggesting was rather than saying quasi-governmental entity includes the University of Maryland medical system, we just, everything that would have applied to them in this bill, we just add that it will apply to them, but we don't name them as a quasi-governmental entity. So we have the same outcome just through a different means. I don't know. Dia, sorry, your hand's raised.
For the lawyers on the subcommittee, when they talk about Freedom of Information Act requests and stuff like that, if they're designated as a quasi government entity, that makes it easier for the public to get Public Information Act from them?
Yes.
Well, then shouldn't they be quasi? Because there's nothing wrong with transparency and the ability of the public to be able to get information from an entity like that probably spends a lot of public taxpayer dollars. So what would be the downside to that?
Delegate Stewart.
Yeah, so Delegate Clark, you and I agree here. I personally consider them a quasi-governmental agency. When you look at the budget, when you look at how their members are appointed, when you look at past court cases that I think I mentioned in my at the hearing, I think Maryland's highest court called them an instrumentality of the state relatively recently. So I think it's pretty clear that they're, quasi obviously just means somewhat, So it's very clear that there's a somewhat of a governmental entity in my view. However, I think Dia is saying the reason you would draft it like this and say, okay, this bill applies to quasi-governmental entities, plus, by the way, it also applies to UMS rather than quasi-governmental entities, including UMS, is you're less vulnerable to a court challenge. You could imagine UMS suing and saying they don't actually fall under the statute, even though they're explicitly named, because they're, it's a drafting error, or, basically because they don't fall under the larger definition of quasi-governmental, therefore the bill shouldn't apply to them, which I think they would lose that lawsuit, but you could imagine them making that argument.
But we can, sorry, Delegate Love.
Thank you.
Thanks,
Can we
Delegate.
draft it in a way that doesn't specifically exclude them as a quasi-government?
Oh yeah, they're not. There's nothing that, I mean, even if it didn't say, right now it says quasi-governmental entity means an entity that is created by state statute, and then underneath that, quasi-governmentality includes the University of Maryland Medical System. I mean, one could make the case that we don't even need that second line because they are a quasi-governmental entity, but that is a clarifying line, right?
Right.
But make sure that they are actually covered by this bill, we are going to, do belt and suspenders, and rather than putting that there, just go to the section that would apply to the quasi-governmental entity and say it applies to UMS.
Right. The way Delegate Stewart said it, and maybe I misheard him, it was a specific exclusion, excluding them from quasi-governmental entity. And I want to make sure we're including them in this bill, but we're not writing in statute that they are or are not.
Yeah. I agree. I didn't mean to say it otherwise, and that's a great point from a much better lawyer than me, Delegate Love.
Stop. I think we're all in agreement that we want to include them.
Yeah.
Right. Okay.
And we also I think we're in agreement.
There are a lot of lawyers in this subcommittee.
I think we're also in agreement that we don't necessarily want to put our thumb on the scale one way or another, but I mean, I don't want to give them any fodder in terms of a statutory canon, that they can maybe use in a future court case. I think it's important that we're careful there. And I think it's also important that we're having this conversation now in terms of legislative history for the public, that me as the bill sponsor, I'm personally opining that I think they're already included under quasi-government land.
Right.
Thank you to our TV audience.
Delegate Clark.
One more quick question. And for the chair of the subcommittee and the attorneys on here, for me, it seems important that however we write this regulation, that it give some judge somewhere the ability to make that decision, quasi or not. If they don't want to be called quasi, that's fine, but they need to be part of this ethics thing. So
yes,
I want them to be part of it, but not have some judge somewhere make a decision that drags out for 3 or 4 years.
Yeah, we agree.
We agree. Okay. Yep. No, we agree. So we will get an amended draft. Patrick and Dia, we can work together and get an amendment drafted to make sure that this applies to them, but that we change in the method that we use to ensure that it applies to them. And then we'll also ensure that we address the one other issue on whether it applies to incumbents as well. Is there any disagreement that it should apply to incumbents? The training portion of it, that incumbents should get trained. Does everybody agree with that?
Well, I might agree with that because we have some the clerks, the wills, register wills, and county clerks that. I mean, we got to register a wills lady. She's 85 years old. She's held the office for 40 some years, and her mother had it before that.
Great.
So, I mean, do we?
I bet she loves to learn, and she wants to learn all about ethics laws.
Maybe by the time this goes in effect, she won't run next year.
Maybe.
I don't know.
Maybe. Dia? You're on mute. Sorry.
Before we moved on, and I apologize, I need to excuse myself in a couple minutes. I think the Ethics Commission might want to try to clarify some of the language on the disclosures related to conflict of interest, financial interest exceptions. This is page 9, lines 22 to 23. The language that would require the Ethics Commission, if they granted certain exceptions, to share that information with the Ethics Committee. I think the Ethics Commission might have some clarifying language on that.
Jennifer.
Oh, thank you. Yes, thanks, Tia. Yes, again, this is Jennifer with the State Ethics Commission staff. With that I guess the language there that's in the bill, the summary of the Ethics Commission's advice associated with the granting of the exception. I think our thought is that may be sufficient, I guess, to capture what, if there is an exception granted for employment or financial interest, and then the State Ethics Commission just puts together the summary of that advice to forward to the Joint Committee, that we were more comfortable with that, just because sometimes the State Ethics Commission, in reviewing advice, reviews things that don't belong to the State Ethics Commission. They may be documents that are coming from or between other parties that the Commission reviews, but the Commission is not a party to that agreement. And so with the summary of the ethics advice, then that could be something that is completely the State Ethics Commission's, and be more comfortable with that language. Thank you.
Have you had a chance to talk to the sponsor about this?
No, I haven't spoken with Delegate Stewart.
So I would suggest that you and Delegate Stewart talk through the repercussions of that. And then if there is an agreement on what amendment language could look like, we can circulate that with the other two amendments around the subcommittee. Does that work?
Okay. Yes, thank you.
Great.
All right. Okay. Madam Chair, can I say a couple things? Mm-hmm. First of all, if you can keep me in that loop with the sponsor and the Ethics Commission, I'd appreciate that, and probably Dia too. Second of all, I just want to remind the subcommittee that this bill doesn't require UMS to do anything. This requires people who do business with UMS to report that relationship. So we're not burdening UMS at all.
Right.
Third is that we're going to have to run this by the chairman to run it by leadership with the fiscal note. We'll that can be taken care of before our next meeting. No problem.
Yep. Okay.
Yeah, it's slightly over 100,000.
Okay.
And I think just for 1 year, or?
Oh yeah, it's 190.
1 year, 190.
1 year, 190.
Great. Okay. We will do that for sure. Great. Excellent. So please, if others have questions over the next week, please let us know. Talk to Delegate Stewart, talk to Dia, talk to me or Patrick, and thanks for the discussion. We had one other ethics bill sitting in our committee, and that is 1229 that we heard last week. That has to do with local officials and electronic filing of financial disclosure statements. Patrick, do you want to give us a quick summary?
Once again, I think you just did it.
Okay, sorry.
Electronic format for local ethics filings. And it's not specific as to what you have to use either. It looks like you could use a screenshot, email, that type of, which is probably why the fiscal note's at 0.
Right. There's one other section of it that is also relevant. It notes that regulations adopted by a school board under this section also shall require that a financial disclosure statement be filed. So I'm wondering, I don't know, I'm not sure if Dia or Jennifer or Patrick, any of you know this. So I am not clear right now on whether school board, every county has a different school board system. So just curious about the school board element of this and whether that's new, because it hasn't applied to them before. So now they will need to file financial disclosure statements or what?
It's not new.
It's not new. Okay.
It's not new.
So they will but they will also have to file them electronically then. Okay.
Correct.
Yeah. Delegate Love.
Thank you, Madam Chair. My question is why we are saying they shall require it be electronically. Shouldn't we include electronic filings with others as opposed to requiring only electronic filing?
What does it look like right now? Yeah, I guess it's not. And shall require that a statement be filed in. Oh, I see. So you're saying
allow for it.
Right.
Yeah,
so
allow for it.
Right.
Well, the state requires it now.
That's true. It does.
We do. We do have to require it electronically. Yep. Is there opposition? I can't remember. Did MACO or MML have, or
No.
Abe have anything to say about this? No.
Surprisingly not.
Okay. Interesting.
Well, then maybe it's not an issue if no one opposes it.
Yeah. Okay. Thanks. Well, we'll hold both of these bills today. And if folks have questions or want to discuss them over the next week, certainly let me know. I'll make myself available. And, my hope is that we can do some voting next Tuesday. So thank you. I will see you all in 33 minutes. Thanks, everybody.
Thank you.
Have a great day.